Lawyer, you're on the clock.
So today, Tanya, I've got three topics for you. The first one's going to be a new decision from a federal court that governs Louisiana and Mississippi, and it relates to the Pregnant Workers Fairness Act. Interestingly, in this case, on the eve of the effective date of the EEOC's final Pregnant Workers Fairness Act regulations, their final rule, a federal court in Louisiana postponed the effective date of what the court describes as the final rules requirement that covered entities provide accommodation for the elective abortions of employees that are not necessary to treat a medical condition related to the pregnancy, end quote, until final judgment is entered in pending litigation. So this order really only impacts employers with employees working in Louisiana and Mississippi. The EEOC's final rule was supposed to go into effect just on Tuesday of this week, June 18th. And this federal court decision from Louisiana does postpone that with respect to just certain employers in Louisiana and Mississippi. So this is not a broad federal ruling. It applies just in those states. I want to make it very clear there are a couple of other lawsuits that were challenging this Pregnant Workers Fairness Act final rule. 17 states had filed a lawsuit in the Eastern District of Arkansas. That case was dismissed and is likely to be appealed. Previously, a federal court in Texas in a different case permanently enjoined the EEOC, the Department of Justice, from enforcing the PWFA against the state of Texas in February 2024 when it found that Congress improperly passed the Consolidated Appropriations Act of 2023, and that case is currently on appeal. So what all this means for private employers with at least 15 employees across the country is that the EEOC's final rule is in effect as of June 18th, 2024. Litigation is going to continue to work its way through the courts. And for now, the only private employers, other than the plaintiffs in that particular lawsuit in Louisiana, the only private employers impacted by that Western District of Louisiana's decision pausing the effective date of the final rules requirement that covered employers provide accommodations for elective abortions are employers with employees in Louisiana and Mississippi. So I want to stress that this is not a very, very broad ruling. All right, so then we're going to shift over and I want to talk about two other cases that are somewhat related. And this is also very, very recent news in the last week or so. An NLRB judge ruled that Starbucks violated federal law by sending its baristas home for wearing union t-shirts. In this case, the judge issued his decision last Wednesday, a week ago, yesterday, and he called it jarring that workers at Starbucks unionized Caesars Bay Cafe were the only company employees in the area to be sent home for a single dress code violation, which was wearing a union t-shirt. Meanwhile, Starbucks baristas in the area at other stores, according to the judge, often flouted the dress code rule that the workers were punished for violating wearing graphic t-shirts as well as other dress code rules. And so the judge held that the only logical conclusion to draw from these facts is the message on the union t-shirt raised respondent ire, and its stricter enforcement of the dress code sought to discourage union and other protected activities taking place at the particular store. And it would be unlawful for an employer to enforce rules more strictly in response to union activity. So what the point of the case is that the NLRB judge is saying that the employees, the baristas who wore pro-union shirts at work were disciplined more harshly. They were sent home after a single violation than other employees who wore other types of graphic t-shirts, which violated the dress code rule, and they were not treated as harshly. They were not sent home immediately or disciplined immediately. So we get to what appears to be a case of inconsistent enforcement of an otherwise valid rule. Although curiously in this case, the judge did say that moving forward, Starbucks is to cease and desist from disciplining employees from wearing T-shirts, and then interestingly, to take the ban on graphic T-shirts out of its dress code, calling the ban overly broad and saying Starbucks didn't justify it. That's the part of this case that I think could end up in the federal court system. And my hunch is that the NLRB judge went too far saying that Starbucks could not ban graphic T-shirts as part of its dress code. So we'll have to keep our eyes on that one. Also, with Starbucks in the news, shifting gears just a little bit, this is really a pretty big development that took place at the end of last week. And basically, unless you've been, living under a rock the last few years, you clearly are aware that Starbucks has been fighting a very tough battle over unionization of its employees. In dealing with the union, seeking to represent its employees, Starbucks has also really had to deal with the NLRB quite often, which has, as I mentioned several times, been acting through its very aggressive and openly pro-union general counsel, the board's general counsel. And they have filed dozens of unfair labor practice complaints against Starbucks, alleging that Starbucks is engaged in a wide range of purportedly unlawful conduct when responding to union organizing. The particular case that the Supreme Court decided was whether the NLRB should benefit from a lower standard of proof for obtaining injunctions against employers like Starbucks that would require employers like Starbucks to restore the status quo that existed prior to the alleged unfair labor practice, while the legal challenge to the alleged unfair labor practice is pending before the board. In this particular case, the board had obtained an injunction against Starbucks requiring Starbucks to rehire terminated employees, while the underlying unfair labor practice complaint was litigated before the NLRB. And again, there are several federal circuits out there, the 3rd, the 5th, and the 6th circuits, that only require the NLRB to demonstrate that there is reasonable cause to believe an unfair practice occurred, and that injunctive relief would be just and proper in order to secure an injunction. There are other circuits out there, the 4th, for particular for our listeners, the 7th that covers Illinois and Indiana, and the 8th, which covers Missouri, and then the 9th Circuit as well. They utilize the more rigorous and traditional 4-part test to gauge whether temporary injunctive relief should be granted before a matter is fully and finally litigated to judgment. And so that test evaluates whether the NLRB is likely to succeed on the merits of the underlying unfair labor practice complaint, whether there is irreparable harm that will result in if an injunction does not issue, the balance of the equities tips in favor of injunctive relief, and an injunction is in the public interest. So again, very significantly, the Supreme Court decided that the case was really simple enough. It boiled the issue down to this question: does the NLRB enjoy a lower burden to obtain injunctive relief than other litigants, or does the traditional 4-part test apply? The Supreme Court here was nearly unanimous. Only Justice Jackson partially dissented, but she did ultimately concur in the court's judgment to vacate the injunction here and remand the case to the 6th Circuit. Justice Thomas wrote for the majority, and he said he rejected the NLRB's position that a lower burden applies to NLRB's request for injunctive relief, and the court held that instead that traditional 4-part test, likelihood of success, irreparable harm, balance of equities, and public interest applies. And so this does substantially weaken the NLRB's ability to obtain injunctive relief against employers. And we've talked about it on the show before. We've talked about the Chevron deferral standard before, that's before the U.S. Supreme Court right now. I personally think this foreshadows a little bit about where the Supreme Court is heading on Chevron deferral. And as I've opined before on the program, I think that that 40-plus-year-old standard of Chevron is probably in jeopardy. But we'll see how it plays out. And with that, that's what I've got for you.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.